Assalamualaikum warahmatullahi wabarakatuh. My name is Nurul Athilah binti Suhaimi, 1172182 from TLB6, and I will be presenting on my individual video presentation under the topic of the position of intoxication as a defense in sexual offences under the Penal Code reference to criminal liability. This is basically the overview of my presentation. First, I will introduce on what is meant by intoxication. Moving on to the difference between specific intent and basic intent. And lastly, I will be focusing on the position of intoxication as a defense in sexual offences. To start with, the word intoxication is not specifically defined in the code. However, this word can be found in various laws dictionaries. For example, in a Dictionary of Law, 2nd edition 1983, defined the word intoxication as a condition of stupefaction induced by alcohol or narcotics. In practice, the term intoxication is used synonymously to drunkenness. The intoxication defense applies in very limited circumstances and typically depends on whether the intoxication was voluntary or involuntary and what level of intent is required by the criminal charge. Generally, there are two types of intoxication, which are involuntary intoxication and voluntary intoxication. What is meant by involuntary and voluntary intoxication are: for involuntary intoxication, the cause of intoxication is not because of our own action, or it is not our will to be drunk or to be intoxicated. Usually, this type of intoxication occurs when someone is tricked into consuming a substance like drugs or alcohol, or when someone is forced to do so. It may also occur as a result of an allergy to or the unintended effects of a legal prescription medication. For voluntary intoxication, the cause of intoxication is because of our own action, or the will to be intoxicated or to be drunk is our own will. Unlike involuntary intoxication, establishing a defense of voluntary intoxication is much more difficult than involuntary intoxication. Under prevailing legal standards, voluntary intoxication is an applicable defense only for certain crimes, and even in those circumstances, juries are far less likely to accept a defense of intoxication when the defendant brought the intoxication upon himself or herself. The case of R.V. Hardy is the example of involuntary intoxication. In this case, the defendant had voluntarily consumed up to 7 old Valium tablets, which is a non-controlled drug having a sedative effect, for the purpose of calming his nerves. While under the influence of the drug, he had started a fire in the flat in which he had been living, but claimed to have been unable to remember anything after taking the tablets. The defendant was convicted of causing criminal damage, being reckless as to whether life would be endangered, following the trial judge's direction to the jury that self-induced intoxication was not available by way of defense to a basic intent crime. The defendant later appealed. The conviction was quashed on appeal on the grounds that he could not be expected to anticipate the tranquilizers would have that effect upon him. So in this case, the type of drug which is Valium is a non-controlled drug, which meant that we don't have to meet a doctor to be prescribed with this type of drug, and known to not have an extreme side effect. Therefore, the court quashed the conviction, and the Court of Appeal held that the trial judge should have distinguished Valium, a sedative, from other types of drugs such as alcohol, which were widely known to have socially unacceptable side effects. While the voluntary consumption of dangerous drugs might be conclusive proof of recklessness, no such presumption was justified in the case of non-dangerous drugs. The jury should have been directed to consider whether the defendant had been reckless in consuming the Valium, in the sense that he had been aware of the risks associated with its consumption, although not necessarily aware of the risk that he would actually commit aggravated criminal damage. Applying to the Malaysian Penal Code, this defense of intoxication is stated under Section 85 and 86 of the Code. Under Section 85, it should be made clear that, as a general rule, intoxication or voluntary drunkenness shall not constitute a defense to any criminal charge. This section only provides a defense for incidents or non-voluntary drunkenness. In Section 86, deals with effect of a successful plea of intoxication as a defense. To summarize, under Section 85, intoxication can only be successfully pleaded as a defense under the Code if an accused person can prove that by reason of an intoxication at the time of the act or omission complained of, 1. He did not know the act or omission was wrong or did not know what he was doing. This was stated under subsection 1 of Section 85. And 2. That the state of intoxication was caused without his consent by the malicious or negligent act of a third person, or 3. That the accused was, by reason of his intoxication, insane at the time of question. If the defense sought falls within subsection 2A of Section 85, then an accused person should be acquitted. On the other hand, if the defense sought falls within subsection 2B of Section 85, then an accused person should be detained at the pleasure of the YDPA, that is to say, the court should determine his insanity under Section 84 of the Penal Code and read together with the provisions of the Criminal Procedure Code under subsection 347 and 348. This is the only provision where an accused person who got intoxicated voluntarily could invoke in order to benefit the defense of intoxication, that is, he was so intoxicated that he became insane. The case of PP v. Kenneth Fook Moon Lee pointed out the defense of intoxication as in the Penal Code. In this case, the learned judge, referring to subsection 85 and 86 of the Penal Code, said it will be observed that the two sections contemplating different levels of intoxication are designed to meet three different situations. Firstly, by virtue of section 85 2A, intoxication is a defense to any criminal charge if by reason of the intoxication the accused at the time of the act or omission complained of did not know that such act or omission was wrong or did not know what he was doing, and his state of intoxication was caused without his consent by the malicious or negligent act of another person. In this situation, the accused is entitled to an acquittal. Secondly, by virtue of Section 85 2B, where the accused is by reason of intoxication rendered insane, temporarily or otherwise at the time of his act, he is entitled to a special acquittal by reason of insanity. The intoxication could ever have been caused voluntarily. In the event of a finding under this subsection, the accused will be dealt with under Section 84 of the Penal Code and subsection 347 and 348 of the Criminal Procedure Code. Thirdly, under Section 86(2) provides that where the accused is intoxicated, voluntarily or not, his intoxication is to be taken into account for the purpose of determining whether he had formed any intention, specific or otherwise. The subsection does not refer to other mental elements such as knowledge or rashness. The onus of proving the defense of intoxication lies on the party that raises this defense. In the case of PP v. Mohammed Jantan, the burden of proof to establish intoxication is on the accused. This is in line under Section 105 of the Evidence Act 1950. This is particularly significant in the case under the situation of Section 86, subsection 2. So we are in the second part of the presentation, which is the difference between basic intent and specific intent. The law draws a distinction between crimes of basic intent and specific intent. The distinction between these two crimes was laid out in the case of DPP v. Beard, where a specific intent is an essential element in the offence, evidence of a state of drunkenness rendering the accused incapable of forming such an intent should be taken into consideration in order to determine whether he had in fact found the intent necessary to constitute the particular crime. If he was so drunk that he was incapable of forming the intent required, he could not be convicted of a crime which was committed only if the intent was proved. In a charge of murder based upon intention to kill or to do grievous bodily harm, if the jury are satisfied that the accused was, by reason of his drunken condition, incapable of forming the intent to kill or to do grievous bodily harm, he cannot be convicted of murder. The decision of DPP v. Beard was followed in the case of DPP v. Majewski. In this case, the defendant had been convicted of various counts alleging actual bodily harm and assaults upon police officers. The offences had occurred after the defendant had consumed large quantities of alcohol and drugs. The trial judge had directed the jury that self-induced intoxication was not available as a defense to these basic intent crimes. The defendant was convicted and appealed unsuccessfully to the Court of Appeal and the House of Lords. With crimes of basic intent, as his lordship explained, the fourth element is supplied by the defendant's recklessness in becoming intoxicated. This recklessness being substituted for the mens rea that the prosecution would otherwise have to prove. So the difference between basic intent crimes and the specific intent crimes is on the intention of the accused. For basic intent crimes, the accused does not have to prove that he has the intention to execute the crime in the state of intoxication in order for the court to convict the person with the crime. However, for specific intent crime, the prosecution need to prove that the accused has the intention to commit the act in the state of intoxication in order for the accused to be found liable for the crime. Other example for basic intent crimes are false imprisonment, kidnapping, and manslaughter. For specific intent crimes, the example of these crimes are theft, burglary, robbery, and murder. So now we can see the application of specific intent crime and basic intent crime in involuntary intoxication and voluntary intoxication. For involuntary intoxication, if a charged crime is a specific intent crime, meaning that the criminal defendant must have had the specific intent to commit the crime in question, involuntary intoxication can be a defense to criminal charges if it prevents the defendant from forming the intent that is required. Involuntary intoxication also can be a defense to a general intent crime if the defendant can establish that the involuntary intoxication acted similarly to an insanity defense and prevented the defendant from understanding the nature of his or her actions or differentiating between right and wrong. For voluntary intoxication, unlike involuntary intoxication, voluntary intoxication is never a defense to a general intent crime. However, voluntary intoxication may be used as a defense to specific intent crimes if, as with involuntary intoxication, it prevents the defendant from forming the criminal intent necessary to commit the crime. In some cases, the defense of voluntary intoxication does not completely absolve the defendant of liability, but instead can reduce the overall culpability for the crime. So we can see here for involuntary intoxication, involuntary intoxication can be a defense for both basic intent crimes and specific intent crimes. But for voluntary intoxication, can only become a defense for specific intent crimes, but not basic intent crimes. In the case of R.V. Littman, the appellant had taken some LSD. He was hallucinating and believed he was being attacked by snakes and descending to the center of the earth. While in this state, he killed a girl by cramming bed sheets into her mouth. He claimed to have had no knowledge of what he was doing and no intention to harm her. His defense of intoxication was rejected at his trial and he was convicted of unlawful act manslaughter. His appeal to the Court of Appeal was dismissed. The weak jury LG said, for the purposes of criminal responsibility, we see no reason to distinguish between the effect of drugs voluntarily taken and drunkenness voluntarily induced. So in this case, the appellant was voluntarily intoxicated himself with the drugs and then committed a basic intent crimes, which is manslaughter. As we know earlier, the voluntary intoxication cannot become a defense for basic intent crimes. Therefore, in this case, he was found liable for the crime. Next, in the case of R.V. Allen, the appellant consumed some homemade wine. This had a much greater effect on him than anticipated. He then committed sexual assaults and claimed he was so drunk he did not know what he was doing. He argued that he had not voluntarily placed himself in that condition as the wine was much stronger than he realized. The intoxication was still voluntary, even though he had not realized the strength of it. The crime of sexual assault is one of basic intent and therefore the appellant was unable to rely on his intoxicated state to negative the mens rea. So this is another example of a basic intent crime was committed in the state of voluntary intoxication. Now we have come to the third part of the presentation, which is the application. According to the Malaysian Penal Code, rape is defined as sexual intercourse with a woman against her will or without her consent. Sexual intercourse with a girl under 16 years of age with or without her consent is also rape. Sexual intercourse with a woman is a rape when, first, her consent is obtained by putting her in fear of death or hurt. Second, when she is unable to understand the nature and consequences of what she is consenting to. And third, when her consent is obtained by using a position of authority, a professional relationship, or other relationship of trust. So we have come to the main question of this presentation, which is rape a basic intent crime or specific intent crime? Actually, this question had been answered in the previous case of R.V. Allen, but I will still proceed. In the case of R.V. Wood, the appellant committed crime while intoxicated. The accused pleaded that he was so drunk that he had not realized that his victim had not provided consent. The crime of rape was one of basic intent and therefore the defense of intoxication was not open to the appellant. So it has been decided in these two cases, R.V. Allen and R.V. Woods, that rape is one of basic intent crimes, which is in the event of involuntary intoxication, it can be a defense. Intoxication can be a defense in respect of rape crime. However, for voluntary intoxication, can never be a defense to rape crime. Basically, there is no rape cases with the defense of intoxication in Malaysia. However, I came up with this case because there is the element of rape, although rape is not the main crime. So in this case of Wong Poh Ling v. PP, the appellant's girlfriend going out with the deceased whom she befriended on the internet. They went for dinner and thereafter they had sex at the deceased's place. The deceased sent appellant's girlfriend home. The appellant's girlfriend informed the appellant that she was raped by the deceased. The appellant asked his girlfriend to call the deceased for them to meet. Then the appellant suddenly came out of the car with a samurai sword. The appellant started to attack the deceased from the back. The deceased fell. The appellant did not deny his presence at the crime scene at the time stated in the charge. He contended that he went to the scene at the behest of his girlfriend. Because the appellant was quite intoxicated, he merely followed his girlfriend. So in this case, there were two experts who gave their opinion on this matter. To be summarized, one expert said that the appellant was in a state of insanity by virtue of intoxication due to taking ice, domicum, and alcohol to the extent that he did not know what he was doing. However, another expert said that it was self-intoxication and his conscious, cognition, and perspective had not been disturbed in the past where he could carry out his activity, and on the date of the alleged offence, there was no much significant increase in the cocktail which he took. So the court, in their judgment, said that the learned trial judge had two diametrically opposite opinions from on whether the appellant was intoxicated by any reason thereof, he was insane, or otherwise such that he was not aware of what he was doing. His lordship acknowledged that intoxication can be a defense under Section 85 of the PC if by reason of the intoxication the appellant was incapable of knowing the nature of the act or that he was doing what was wrong or contrary to the law. Having considered the legal principles on the defense of insanity and having evaluated the evidence of the experts, the learned trial judge found that the appellant was not medically insane, let alone legally insane. The law on intoxication, as can be gleaned from Francis Antonisamy VPP, requires the court to consider the appellant's conduct prior to, at the time of, and after the commission of the offence. It was said in the judgment of the case, it must be observed that what is in issue in a defense of intoxication is the state of mind of the person concerned in order to determine whether he could have formed the necessary intention. The best evidence to establish his state of mind is his conduct prior to, at the time of, and after the offence, as different people react differently to the same blood alcohol level. Needless to say, scientific evidence is significant to explain the conduct of the person. In other words, it will corroborate the evidence conduct. Its absence cannot therefore be fatal. So in this case, the court, in order to determine whether the appellant was intoxicated, was really intoxicated at the point that he did not know what he was doing, or insane because of intoxicated, the court referred to this case, which is said that we must observe the appellant's conduct prior to, at the time of, and after the offence to really see whether the defendant or the appellant was in the state of intoxication or not. The court found that prior to the incident, the appellant's conduct disclosed that his state of mind was not impaired. Similarly, at the time of the commission of the offence, the conduct of the appellant revealed that his mental state was not impaired by the consumption of the drugs and alcohol. He was alert and conscious of the surroundings, which indicated that he was not intoxicated, such that he did not know what he was doing, as apparent from his testimony. In concluding that the appellant was not legally insane, the learned trial judge, apart from analysing the evidence of the experts, considered the evidence of the appellant that from where he was seated at the front passenger seat, he could describe vividly how the incident unfolded. The learned trial judge found that the appellant could not possibly be intoxicated as that would be inconsistent with his ability to describe in court what he alleged had happened on the day of the incident. So, following to the earlier case, the court, in order to determine the appellant whether he is intoxicated or not, must observe the appellant's conduct at the time and after the offence committed. So in this case, the appellant remember what happened during that day, even though he said that he is intoxicated. So the court held that the appellant's state of mind was not impaired, means that he was not so intoxicated that he did not know or did not remember what he was doing. His state of mind was still in the ability to remember and was still in the ability to know what he was doing was wrong. So the court held that the appellant had failed to establish the defense of intoxication under subsection 85 2b of the Penal Code on the balance of probabilities. The court therefore dismissed the appeal and affirmed the conviction and sentence of the High Court. So in this case, although rape is not the main crime in this case, but we can see how the Malaysian court determine a person's criminal liability in the event of intoxication. So in this case, murder is one of the specific intent crimes. Therefore, intoxication can be used as a defense, both intoxication, either voluntary or involuntary. So in this case, the appellant voluntarily intoxicated himself and executed the act. So how the court determined that he was intoxicated or not, the court referred to the appellant's conduct prior to, at the time of the conduct, at the time of the crime, and after the crime was committed. So in this case, it was held that it was found that the appellant was not so intoxicated to the point that he did not know what he was doing, and the defense of intoxication cannot be used in this case, or cannot be established in this case. As a conclusion, we can see that intoxication can be a defense to a crime, to both basic intent crime and specific intent crime, although there are several requirements or procedures that the court need to take in order to determine whether the defendant was really in the state of intoxication. So in respect of rape offences or sexual offences in Malaysia, I think any defense counsel must have the knowledge that intoxication can never be a defense to basic intent crime, which is rape. And there is, as my research on, there is still no decided cases on involuntary intoxication in rape cases. And with that, I conclude my presentation. Thank you for listening, and sorry if this presentation is too long. I was not intended to do that, but that happened, and thank you for your attention. Have a good day, sir.